Welcome everyone. We are so pleased that you have joined us for today's webinar titled Recent Buy-Sell Court Case Shows Potential Traps for the Professional Team. The webinar today will last approximately 15 minutes, and at the end you will be given an opportunity to receive supporting materials by email, free of charge to you. You will also be told how many you can email questions related to today's content to the presenter. Today's presenter is Linus Sugis. Linus worked for a Chicago-based insurance company in various roles, including Director of Advanced Sales and as Chief Marketing Officer. He ran and sold a successful estate planning law practice. Linus now writes extensively for life insurance industry publications, and he speaks regularly at industry events. His new book, Sell Out, The Busy Entrepreneur's Guide to Transferring a Closely Held Business, written together with a CPA and a business broker, will be available soon on Amazon.com. Linus will draw on his legal, life insurance, and practical experience for today's webinar. And here he is.
Thank you very much, Lisa, and I'd like to thank all of you for attending what is the second in a series of monthly First Wednesday webinars. During these webinars, we're covering topics of interest to life insurance professionals and financial planning professionals. And this month, we've got kind of an interesting case, a federal court case out of Pennsylvania that we'll talk about, which gives, I think, some great lessons on buy-sell planning. We're going to spend 15 minutes reviewing the case and discussing its implications for planning professionals. So during last month's webinar, we talked about the importance of reviewing a business owner's buy-sell arrangement to make sure that it covers everything that an entrepreneur should be worried about. A lot of life insurance professionals visit with business owners about death time planning, and that's understandable. But I think it's also important to talk about lifetime triggers so that the planning professional is positioned as somebody who is really helping the business owner think through a lot of the issues. Now today we're going to talk about a case where death time planning could have gone better. The buy-sell agreement and the funding in this case were nearly right, but implementation flaws still led to litigation between the parties. So the federal district court decided Broderdorf versus Batchelor, which was a one-way buy-sell case where the buy-sell insurance proceeds ended up not being used as the business owner probably intended. Now this case has not been finally decided, so the ultimate outcome is still in doubt. However, in my opinion, the professional team involved with implementing this particular buy-sell structure could have helped the parties avoid this expensive and uncertain litigation. And so we're going to talk about what they might have done differently. But in order to talk about what they might have done differently, I think it's first important to understand what in fact they did. So here's a little background on the case. Amy Bozick was the founder and sole owner of Flying Nurses International, a medical escort service that specializes in commercial airline medical transports, and it also supplies nurses to escort travelers who have fallen ill or suffered injury while traveling abroad. Robert Batchelor had been an employee of FNI since 2007, and he worked as a flight nurse and a flight coordinator. So the original company agreement for FNI was drafted in 2011, and that agreement gave Batchelor a right of first refusal to purchase FNI upon the death of Bozick. It also provided for Batchelor to purchase a life insurance policy on Bozick's life as a means for paying for FNI at her death. Now, the agreement had some specific provisions. The 2014 original agreement had some specific provisions that dealt with the life insurance policy. It specifically said the life insurance policy has been put in place, which is payable to the sole member's estate, that's Bozick's estate, as a portion of the purchasing funds. And it also had language that made it clear that Batchelor had a right of first refusal to buy the company in the event of Bozick's death. And if but Bozic retained the right to sell to a third party. It wasn't so clear whether that was during lifetime or after death. Certainly during lifetime was intended. After death was a little bit up in the air. But what it did make clear was that Batchelor was going to be reimbursed for the premium payments if the company was sold to a different third party. And it was clear that, that both the owner of the company, Bozic, and Batchelor were parties to the agreement. So after the original agreement was signed, the parties entered into a new agreement in 2014. Before that happened, they bought life insurance. Bozic applied for life insurance in 2012, applied for a policy on her life, named her estate the beneficiary. The insured's husband was designated as contingent beneficiary, and Bozic listed Batchelor as the owner on the policy, and it turned out that Batchelor paid all the premiums for the policy. Now, the facts don't say, but it might very well be that that Batchelor was paid a bonus to cover the premium for the policy. Might be that Batchelor used his own money for the premiums. It's not clear, and the facts don't really lead to a clear path as to what might have been done. What's the problem with that particular setup? Well, the problem with that setup is that if Batchelor is the owner of the policy on Bozic's life and Bozic's estate is the beneficiary, there's likely to be a tax result on the death benefit when Bozic dies and Batchelor owns the policy, and that's because of the Goodman rule or the Golden rule, which says that if you've got one third party of a life insurance policy and a different third party is the beneficiary, as was the setup here, you've created an income tax or a gift tax result with regard to the death benefit. Because these parties had a business relationship, it's probably an income tax result, and exactly how the IRS might have sorted that out if it was called on with that kind of configuration isn't really clear. There isn't really a straightforward court case that deals with this kind of circumstance. It's complicated also by the fact that the buy-sell agreement would have to be evaluated in conjunction with the way that this is set up, and it would have certainly been a tax mess in the event something happened to Bozic while the configuration was this way. Well, the parties didn't leave things that way. What they did is they first of all amended the buy-sell agreement, and they amended the buy-sell agreement, making it clearer that the life insurance was going to be used to buy the ownership interest in the company. However, the agreement still gave Batchelor an out and said that he wasn't required to buy the ownership interest in the policy, that he could decide not to. And in the event he decided not to, he was going to get paid back for the premium payments he had contributed. And both parties signed that agreement. And Batchelor was made the owner of the policy. Shortly before Bozic's death, Bozic got sick in September of 2014. In December, before Bozic died, Batchelor changed the primary beneficiary of the policy from Bozic's estate to himself. So now Batchelor is both owner and beneficiary of the insurance. Now Bozic, because she's only the insured and not an owner of the policy, at least arguably, doesn't need to consent and did not consent to it. So Bozic dies, Batchelor collects the insurance, Batchelor has the opportunity to buy FNI and refuses to exercise his option to buy and keeps the life insurance money. And so, understandably, Bozic's executor brings suit to try to collect the life insurance money. And one of the first things that the court observes is that Bozic if Bozic had known that Batchelor would, first of all, name himself the beneficiary of the life insurance policy, and second of all, once Batchelor got the money, would refuse to buy the company from her estate, she would never have allowed it. Well, that's a duh kind of moment from the court, right? I mean, that makes perfect sense, but that's in fact what happened. Batchelor collected the insurance proceeds, didn't use the money for the buy-sell, and Bozic's estate got stuck with both the business and with no money from the life insurance policy. So the estate executor got ticked off, brought a lawsuit in Pennsylvania federal court, and alleged 7 different legal theories to try to collect the insurance proceeds from Batchelor. And Batchelor countered by moving to dismiss the lawsuit, saying that he was the beneficiary of the life insurance and that should kind of be the end of the story. And the court decided that no, there was enough evidence with the agreement and the way that the parties acted that there was enough evidence for 6 of the 7 legal theories to move forward based on the evidence that was on the record. And on the 7th potential claim, the court said that the executor could actually amend the complaint to give a cause of action. So the court denied Batchelor's motion to dismiss, essentially allowing the lawsuit to go forward and kind of implicitly indicating that 6 of the 7 claims that the executor brought against Batchelor were going to be valid if the facts could be proved. And so while this wasn't a complete disposition of the case, it does kind of indicate that the court was ticked off with Batchelor, the key employee. The court was ticked off with Batchelor cold-bloodedly keeping the money and refusing to exercise the buy-sell agreement, and that if forced to rule sometime in the future, it seems likely that the court is going to rule in the estate's favor. And so what seems likeliest to me is that the parties will negotiate with each other to settle this case, and probably most of the insurance proceeds will be turned over to the estate. It's not clear what will happen with the business, but the insurance proceeds will likely end up in the estate. So what are the lessons from this case? Well, I think the first thing is that if you've got a one-way buy-sell situation like this, where a key person is going to buy out the owner of the company, the parties could have made the buyout mandatory. And if the buyout obligation was mandatory instead of optional, it's likely that this lawsuit would never have happened. That Batchelor would have been required to use the money to exercise the buyout, and the money would have ended in the right hands. Batchelor would have ended up with the business, and it would have been more in line with what the parties had intended. In the alternative, Bozic could have kept ownership of the life insurance policy. That's not usually the way that we set up one-way buy-sells. Usually the ownership is in the hands of the key employee, but when ownership of the life insurance is in the hands of the key employee, there's an obligation on the part of the key employee to do the buying. And so if the buy-sell was optional, probably Bozic would have been better served to hedge her bets and keep ownership of the life insurance policy herself, and keep herself as the beneficiary. In conjunction with that, Bozic could have perhaps insisted on a collateral assignment against the policy's death benefit as a condition of the policy transfer to Batchelor, or as a condition of naming Batchelor the beneficiary. If it's clear that Bozick's estate has a collateral ownership interest in the death benefit that's in conjunction with the buy-sell obligation, that would have protected them a little bit better and would have forced a negotiation on Batchelor's part probably instead of a lawsuit. And then finally, and I think this is a bit of a criticism of the lawyer who drafted the buy-sell, is perhaps as well as the agent who is working with the parties here. The parties' professional advisors probably should have worked together a little bit better to make sure that what was intended to happen in fact did happen. There seems to have been a disconnect between the permissive language, the optional language of the buy-sell agreement, and the ultimate structure of the insurance, which ended up in Batchelor's hands and over which Batchelor exercised complete control, including naming himself the beneficiary. If the professional team had worked together a little bit better to anticipate that possibility and deal with it on the front end, they could have avoided, I think, the lawsuit that ended up happening on the back end. So in conclusion, I think the facts in this case represent a fairly typical one-way buy-sell situation. The business owner intends to sell the business to a key employee. The buy-sell in this case was not a mandatory agreement, which by itself was not necessarily a problem, but certainly contributed to the tough result here. The biggest problem was that Bozick allowed Batchelor to own the policy and change the beneficiary designation to himself without the agreement being mandatory. So both of those things together really created the issue here. Because the estate didn't get any money, they brought this suit. The suit is still ongoing. While that's good news for lawyers, it's not so good for the family. I think as planners, we want to make sure that our clients don't have to sue on the back end in order to get done what they have in mind. And finally, successful buy-sell implementation requires the client, the agent, and the client's own tax professionals to work together and communicate really, really well about the implications of every decision, not only with regard to the life insurance, but with regard to the language in the buy-sell agreement. So having a professional team work together really is the best advice. So thank you for joining us today. If you would like a copy of the Think About It newsletter that covers this court case in some details and demonstrates the traps and covers a lot of the same ground that we covered today during the webinar, feel welcome to email me. If you have questions about today's webinar, feel welcome to email me at the email address listed on the screen. I would invite you that if you would like to continue to listen to these webinars, feel welcome to let Lisa know that you'd like to stay on the list. You can join us the first Wednesday of every month at 11 a.m. Central Time. We will conduct webinars, short webinars on topics of interest to life insurance and financial professionals. Thank you for listening. Feel welcome to join us again next month. And Lisa, would you wrap this up for us?
Will do. Thank you very much, Linus. Again, thank you very much for joining us today. And another reminder, if you would like to receive supporting materials, email Linus. The email is linus.zugis@advancedunderwriting.com. You can also email him questions related to today's webinar. And finally, for more information about the services that we at Advanced Underwriting Consultants offer, including phone consultation, newsletter licensing, feel welcome to contact me at 615-224-1291. Thanks again and best wishes for continued success.